Hello, everyone. Welcome to the very first webinar for 2023, hosted by the Queensland Sentencing Advisory Council. My name's April Chrzanowski, and I'm the Director of the Secretariat for the Council, and I'll be your MC for this session. I'm delighted to have you all here to join us today for this really important presentation in relation to our recent research into sentencing of offenders in Queensland who are aged under 14 years. Before we commence the proceedings, though, I would, however, like to acknowledge the traditional owners of the land on which we meet today and pay my respects to elders past, present and emerging. Here in Brisbane, otherwise known as Meanjin, we meet on the traditional lands of the Turrbal and Yuggera people. I also extend my respect to Aboriginal and Torres Strait Islander peoples joining us today and acknowledge the ongoing leadership of Aboriginal communities across Queensland in striving to build on their strengths to address inequalities and improve Aboriginal justice outcomes. By way of housekeeping, I note that this is our very first attempt to run a live webinar event like this, so I do ask that you be patient with us as we put our faith in our technology and our systems to be able to share with you our research results in this way. We also note that this session is being recorded today, and we hope to make a version of that available afterwards. As we progress, we're very happy to take questions and to submit a question at any time throughout the presentation. You should be able to click on the Q&A tab on your MS Teams app or your browser, and the team will be monitoring those questions, and we will respond to as many of those as possible, though we'll do so at the end of the presentation. So, by way of background to this presentation, it's important to understand the Queensland context for this research. Currently in Queensland, the minimum age of criminal responsibility is 10 years. That means that a child under that age cannot be held criminally responsible. Further, a child aged 10 to 13 is presumed at law not to be legally capable of wrong unless the prosecution proves otherwise. So, as many of you are aware, federal, state and territory attorney generals have been examining the issue of potential increases to the minimum age of criminal responsibility for some time, and with some reports recommending that the minimum age of criminal responsibility should be raised to 14 years, and others exploring proposals to raise the age of criminal responsibility to 12. There have been various commitments made at the state and territory level, and in Queensland, the government has said that it will continue to participate in national discussions and work with state and territory and Commonwealth Attorneys General, preferring to take a national uniform approach. So it's against this background that we are here today to discuss the QSAC's recently released research paper that explores the sentencing of young offenders that are aged under the age of 14 years. So to discuss the report and the implications of these findings, I'm delighted to be able to welcome the Chair of the Queensland Sentencing Advisory Council, former Judge John Robertson. John was admitted as a solicitor in 1973 and started his own firm in 1978. He was the Deputy President of the Queensland Community Corrections Board from 91 to 94, and in 1994 he was appointed as a District Court Judge. For his whole judicial career, John was a judge of the Children's Court of Queensland and was president of that court from 1999 to 2001. And during this time on the bench, he served in Ipswich, Brisbane and Maroochydore until his retirement in 2018. In addition to being the chair of the Sentencing Advisory Council, John is also presently a part-time judicial member of QCAT. So we welcome you, John.
Thank you, April. Thank you all for attending this first ever webinar conducted by the Council. April's introduced me, and for those of you who don't know me, I'm the current chair of the Queensland Sentencing Advisory Council. It's a privilege to be in that position and to contribute to this very important issue and debate. April has already acknowledged the traditional owners of the lands upon which we're meeting. Here in the State Law Building, it is the Turrbal and Yuggera people, and I particularly want to acknowledge their elders, both past and present, and their wise ones, and also to acknowledge the tremendous input that our Aboriginal and Torres Strait Islander advisory panel, led by a member of the Council, Nita Ray Marbo, plays in assisting the Council in understanding the issues that impact on First Nations people as a result of sentencing practices and policies in our state. We thought it might be useful to give you a very brief background of how this paper came about. Under the statute that constitutes or sets up the council is given 6 interrelated functions. Not surprisingly, one of the most important is to give information to the community about sentencing with a view to enhancing knowledge in the community of an understanding of sentencing. As you all know, it's an area of public policy that is subject to a lot of public commentary, and there's a lot of interest in what goes on in our courts when it comes to sentencing. We also have a statutory function to research matters about sentencing and publish our findings, and hence this paper. We also have a responsibility to respond to terms of references or requests for research from the Attorney-General. Last year as a council, we identified 2 primary areas of research that we would undertake, subject to receiving terms of reference from the Attorney-General about issues. And these streams are the domestic and family violence area, which needs no elaboration, and youth justice. And this paper obviously is produced as part of that stream. Once again, there's a great deal of interest in the community and in public discourse about sentencing for youth offenders, children. This paper, which investigates the sentencing of offences committed by children who are under the age of 14, was prioritised by the council on the basis that it would be of interest to the broader community, given earlier trends of interest identified in our sentencing profiles published last year on sentencing of children and women and girls in Queensland. And we also considered that it might be particularly timely given the current and active discussion on a national basis in Australia regarding the raising of the minimum age of criminal responsibility, and to give information to the community about the profile of these very young children who come before the criminal courts. In our paper, we review some of those developments and articulate some of the reasons commonly identified for and against raising the minimum age. Briefly, one of the main reasons that is articulated in favour of raising the age from 10 relates to what we now know and really have known for some time about childhood development, particularly neurological development, particularly in the frontal cortex. And this is scientifically based. So we know that the brains of children, and particularly in that area which involves decision-making and acting spontaneously without thought, suggests that the brain doesn't develop until the early 20s, and for males, a little older than for girls or for women. As some of you have known, may know, the United Nations Committee on the Rights of Children has asserted that the minimum age of criminal responsibility should be at least 14 years in the light of that evidence about cognitive and neurologic development of children. Those against raising the age are concerned about community safety and how children in the 10 to 13 year cohort who commit offences could be held accountable and appropriately supported. In our paper, we examine the existing literature, what the literature reveals about this cohort of offenders in Queensland and in other parts of Australia and the United Kingdom. I'm now going to hand over to our research manager, Samuel Jeffs, who is the person that exercises real intellectual heft when it comes to this topic, to discuss how we went about approaching the projects and some of our key findings. Samuel.
Thanks, John. Just give me a second to get my screen shared. I don't know about intellectual heft, but I'll do my best to talk you through our report, our analysis, the data we analysed, touch on some of the findings, and really just try and tease the report so that it's available online. So if you want to read it after I'm done, or maybe you already have, then feel free to access it there. And before I get started, just thanks everyone for tuning in. So I'm going to start with my personal favorite part of any presentation, which is talking about the methodology. You might not agree with me, but I really like when I listen to people talking about their work, hearing about what they looked at, why they looked at it, and so that, yeah, gives you more context to what's going on. So what we did in this paper is we looked at 17 years worth of court data, so data from Queensland courts. Our data period started in 2005 and goes up to 2021-22. So that on the screen is the 17 years that we looked at. And we looked at children who committed offences while under the age of 14. So it doesn't matter how old they were when they were sentenced by a court. What matters is how old they were when they committed an offence. Now, as John discussed previously, there's two current proposals floating around for raising the minimum age. One is to raise the age to 12, and the other is to raise the age to 14. So throughout this report and throughout this presentation, I'll be presenting those two cohorts separately and talking about them separately. So the very first thing we did when we got started is we wanted to know how many are there? How many children are there under the age of 14 that are committing offences? So to put it into context, I've got a big bubble on the screen that represents all sentence cases in Queensland. This is children, this is adults, this is everyone. So over the 17 years, I think it was about 2.5 million sentenced cases. If you just look at children, so this is all children under the age of 18, they represent about 7.4% of sentence cases. But what we were interested in was the very young children, so that's these ones here that were under the age of 14. So there's age 10, 11, 12, and 13. So that's 0.7% of cases. And this is what I'm going to focus on today and what we focused on in our report. Now, before I get into those young kids, though, I just want to take a moment to talk about children generally. So if this is all children under the age of 18 who have been sentenced in the past 17 years, the 12 and 13-year-olds represent the bulk of the cohort we're looking at today, so 8.3%. And that tiny little slither of purple that you can probably barely see down the bottom is the 10 and 11-year-olds, who represent 1.1% of children. So we're talking about, like, if I just go back a bit, we're talking about 0.7% of all sentence cases. But if we just look at children, we're talking about 10% of children who are sentenced, and most of them are the older age bracket. So these are the official numbers we published in our paper. So over the 17 years, there are about 7,200 unique children in this cohort. And if you divide that by 17, you get a yearly average of about 650 unique children being sentenced in Queensland each year. For the younger children, there's a lot fewer of them. There's about 1,100, a little less than that, over the full period, which is about 87 per year on average. Now, in our report, we've also reported quite a bit on court cases as well as unique children, and I'll touch on that a bit throughout the presentation today as well. And I won't go into too much detail, but I will just say that the number of court cases is a lot higher than the number of unique children. And that's because about 50% of these kids in this cohort are repeat offenders. They come before the courts more than once. And so the number of court cases is higher than the number of unique children. So this here is looking at the 17 years of data over time. The purple bar across the bottom is the very young kids, the 10 and 11-year-olds. And just generally what this is showing is that things tended to trend upwards from about 2005 through to about 2017-18. Then pandemic hit, the number of cases sentenced, committed, detected dropped. But interestingly, the numbers haven't seemed to have come back up since that pandemic hit. So they've stayed low since 2019-20. Now, I've spoken a lot about the age of kids, and this is going to be the last slide looking at ages, I promise, maybe. But really what I wanted to show here is that the 10-year-olds, there's so few of them. In fact, you can barely see them on this chart. In fact, can you? Maybe if you get a magnifying glass. But this chart shows the number of cases that were sentenced based on the age of the person being sentenced. Shows everyone, of course, children and adults. Whoops, wrong way. These ones that I've just highlighted are the ones that we're focusing on our report. And if I just zoom into that, this is the breakdown. So 10-year-olds make up 2.8% of this small cohort, whereas most of the cases that were sentenced were for 13-year-olds. So about 2/3 of all the cases that I'm going to show you today were 13-year-olds. About another quarter were 12-year-olds, and then about 10-13% were the very young children. Okay, now to get into some demographics. So this chart breaks it down by gender and Indigenous status. And this is where I'm going to start separating out the under 14s on the left and the under 12s on the right. But if you look at the under 14s for now, about almost 3/4, so about 73% were boys. And slightly more than half were Aboriginal and Torres Strait Islander children. So this is clearly a disproportionate number of Aboriginal and Torres Strait Islander children being sentenced. For this cohort, Aboriginal and Torres Strait Islander children make up about 7.9% of all children aged under 14, well, 10 to 13. But they're making up more than 50% of sentence cases for this cohort. For the under 12s, it's a lot higher. It's almost 3/4 of children are Aboriginal and Torres Strait Islander. So on this chart, it's if you add up both the boys and the girls. So another thing, while we're looking at Aboriginal and Torres Strait Islander status, we also obtained some data from the QPS, from the Queensland Police Service, looking at police diversions. So we asked for data on children under the age of 14 who are being diverted by police, so the ones that weren't proceeded against in court. And just looking at the latest financial year, 2021-22, we found that just over 40% of the cohort diverted by police were Aboriginal and Torres Strait Islander children. Whereas if we compare this to the percentage of children that were sentenced in a court, it was much higher at 61.8%. So this is consistent with previous research that's been conducted in New South Wales by Don Weatherburn and Brendan Thomas. They published a paper a couple of months ago, earlier this year, which showed that when they controlled for a bunch of factors like seriousness of offence and other things, and they found that there was a greater percentage of Indigenous children aged 10, 11, 12, 13 that were being prosecuted rather than diverted by police. And so our slides sort of perhaps show something similar. Now, before we move on from demographics, I'm just going to quickly touch on some trends over time. So this chart here, the top two lines, the solid lines that aren't broken, are looking at boys. So the top one's Aboriginal and Torres Strait Islander boys, and the second one's non-Indigenous boys. And over the 17 years, you can see that the proportion of boys has been decreasing. If you look at the dotted lines now, which is the girls, you can see over the same period, the proportion of girls has increased, particularly for the Aboriginal and Torres Strait Islander girls, where it was, they represent about 11% of sentence cases back in 2005-06, but it's almost doubled to 21% in 2021-22. Now, I'm going to talk about the types of offences that were committed. Now, the way we've split our data here is based on the ANZSOC classification, which is the Australian and New Zealand Standard Offence classification that the ABS put together and publish. And what this is it's a grouping, it's a classification of different offences. So in Queensland, there's hundreds, if not thousands, of different offences. And what we've done here is we've grouped them up into some categories that make sense, so that we can know, so we can display 15 categories rather than hundreds of offences. And what we see here is for the children under 14, the most common categories of offences were theft, unlawful entry, and property and environment. So the theft offences involve most commonly the offence of stealing, but also unlawful use of a motor vehicle, which you could think of as car theft, but all the lawyers online might say, no, not quite. And then also shoplifting is one of the common offences in that theft category, or unlawfully dealing with shop goods, I think it's called. The second category is unlawful entry, which includes both burglary of a home as well as the unlawful entry of a non-home premises, so maybe a shop or a warehouse or something else. And then finally, property environment. There's no environmental offences here. It's mostly property and it's mostly willful damage. And I suspect a lot of those offences are graffiti-related offences as well. So now comparing that to all children and all adults, everyone who's sentenced in Queensland, you can see that the offence profiles are quite different. Adults are more commonly being sentenced for traffic and vehicle offences as the most common one, followed by justice and government offences, and that includes things like breach of bail or breach of domestic violence order most commonly. And drugs, of course, are quite common for adults, but not so common for children under the age of 14. So as I mentioned before, this slide looks at very broad categories of offences. On the next couple of slides, I'm going to drill down to specific individual offences in Queensland. So this is the top 5 offences that were committed by each cohort. And you can probably tell that they're quite similar. So the most common offence for each was unlawful entry. And this is unlawful entry. It's not burglary, it's unlawful entry of something that isn't a home where people don't live. The other common offences are willful damage, damaging property, stealing, and trespass. And so they're all property-related offences, I guess. It's not assaults or offences against the person. It's offences against property. And then the distinguishing factor, I guess, is the 5th offence, which for children under 14 is unlawful use of motor vehicles, whereas for children under 12, it's burglary, which is breaking into a place where people live, a home or a dwelling. Now, before I move on, the majority of these cases that I've been talking about are sentenced in the lower courts. In fact, I think it's 94.5%. So about 95% of all the cases I'm talking about here are the lesser serious cases dealt with in the lower courts. So out of the 19,000 odd cases sentenced over the 17 years, only 919 were sentenced in the higher courts. And by higher courts, I mean either the Supreme Court or the District Court. Well, the Children's Court for this cohort. So I'm now going to show you the top 5 offences that were sentenced in the higher courts. So bear in mind, this is only about 5% of offences, but it is the 5% of offences that are being sentenced in the more serious courts. And this is what it looks like. So there's a bit of a difference between the 2 cohorts this time. The most common offence for each is still robbery. So it's the same for both. But the other ones are a bit different. So for the under 14s, you can see there we've got AOBH, indecent treatment, rape, and attempted robbery. And for the children under 12, it's a bit different. Some of the same offences in a different order: indecent treatment, attempted robbery, rape, and arson. So I guess the point we're trying to make here is, although the majority of cases, 95%, are these low serious ones dealt with in the lower courts, there are still some serious offences being committed by this cohort. Some offences that are against the person now rather than against property. But it is a small volume of children. And since it is a small volume, we can probably target resources, programs, interventions, other things towards this cohort. And to just put it in context, if we look at robbery as an example, that's the most common offence sentenced here in the higher courts for these cohorts. If we put in context of all cases sentenced, so all robbery cases, including adults, children of all ages, the robberies committed by this cohort represent about 3%. And just looking at my notes here, it's about 3.4% of robbery cases are committed by these young kids. So not insignificant, but not large either. Now sentencing outcomes. So we are a sentencing outcome. So it makes sense, of course, that we have a look at sentencing outcomes. Often we often run into the situation where we spend a lot of our time talking about the cohort and the numbers and the offences and everything else, and we sort of get to sentencing outcomes at the end. But it is important to put it all into context before we get to this point. So again, I've got the children under 14 on the left and children under 12 on the right. The most common offence for both cohorts was a reprimand, as you can see down towards the bottom there. And then it was the same order. The top 4 or 5 offences were the same for each. So reprimand was the most common, followed by probation orders, followed by court diversion referrals, good behaviour bonds, and then finally community service. So those under 12, it's quite a similar distribution. There are a few differences, like for example, if you have a look at detention at the top there, there's many more detention orders for the children under 14 compared to the children under 12. I personally don't like using a chart like this to compare one to the other because it's a bit hard to see. So I've got this chart, which shows the exact same information, just presented a bit differently. So we've got the children, again, children under 14 on the right, on the left, children under 12 on the right. And you can see that reprimand and probation are much more common for children under 12 compared to children under 14. Court diversion referrals and good behaviour bonds, which were the 3rd and 4th most common penalty, didn't really change too much, whereas there's a huge difference in community service. So the younger children didn't get many community service orders at all, and that's mostly because community service orders can't actually be made for these younger children. So the very small number of children there that did get a community service order, it's probably because they committed an offence while they were under 12, but they weren't sentenced until later. And so because they were sentenced when they're older, a community service order was able to be made. And then finally, we've got detention there, and you can see that detention orders go from 2.1% for the children under 14 down to 0.5% for the children under 12. So it's 4 times more likely for the older kids. And in fact, if you look at the 10-year-olds, there were no detention orders whatsoever for that cohort. Okay, so now I've done a sort of bit of a mix and match. So we're now looking at the top 3 most common offences. So you might remember from just before, I said the top 3 offences were unlawful entry of a premises, willful damage, and stealing. And now we're looking at these top 3 offences and looking what the sentencing outcomes were for those offences. So for unlawful entry, most of those children got a probation order. So a bit more than a quarter of the cases were probation for an average length of 7.4 months or a median of about 6 months. Willful damage most commonly got a community service order in about 1/3 of cases. Now, this is sort of a special case because if the children, if the damage they caused was graffiti, then the courts can or perhaps must order a graffiti removal order. So you can see that 64% of these community service orders were actually graffiti removal orders. So they're orders to go and remove graffiti. So you can, this is what I alluded to before when I said that I suspect most of these willful damage sentences were graffiti because that's what they were. And then finally, we've got stealing as the 3rd most common offence, and most commonly the offenders were reprimanded. So the children were reprimanded for this offence. Now, this is my last slide, and we're talking about the most serious sentences that were handed down. So we're looking at detention orders over time. So a couple of slides before, we saw that 2.1% of orders were detention orders. And what the line chart here shows is the proportion of detention orders and how they've changed over time. So over the 17 years, it was 2.1%, but you can see there was actually a lot of fluctuation. So in 2011-12, for example, it was as low as 1.1%. And in other years, it was more than 3% of orders were detention orders. The bars there just simply show the number of detention orders that were made. So overall, over the 17 years, there were 379 detention orders. You can see that that ranges from some years being as low as 10 or so, especially in recent years, to other years where there were more than 30 orders made in a year. On average, the length of a detention order was about 5 months. But the types of offences that attracted detention order was most commonly burglary, so breaking into someone's home. So I think about a quarter, about 1 in 4 of the detention orders were for burglary. Now, I mentioned this briefly a second ago, but the majority of these detention orders were for children aged 13, so the older kids. 80%, in fact, were 80% of detention orders were for 13-year-olds. Well, not quite 80%, 78.4%. There were no 10-year-olds that got detention orders. And if you look at 11-year-olds, only 3% of the detention orders were for those aged 11. So some were given for 12-year-olds, but most were given to 13-year-olds. We also in our paper looked a bit at repeat offending. And what we found was for the children who received detention, they all had, 94%, most of them had prior sentenced cases. So 94% of the detention orders, those children had been to court before, had been sentenced before. We had a look at the 6% that had never been to court before, and those first-time offenders that received detention had committed quite serious offences, including things like rape, grievous bodily harm, arson, burglary, robbery, and torture. We also had a look at repeat offending for kids that got a detention order, and we found that 3/4 of children that were sentenced to detention only received that one detention order while they were in this cohort. So they didn't get multiple detention orders under the age of 14. So it was only about 1/4 of kids that did get, so 1/4 of the kids that got detention a second time while under this age. So thanks so much for sticking around with me, everyone. I'm going to hand back to John now to chat about this. Thank you.
Thanks, Samuel. Sorry, I'll just say thank you so much for presenting those results. I think it's amazing when you can have such a technical and quite detailed paper that we have provided, being able to be presented in such a clear and concise way. So thank you very much. But we'd like to then now hand over to John, the chair of our council, to provide his insights and thoughts in relation to what do these findings mean. Thanks, John.
Well, apart from maintaining my comment about intellectual heft, seriously, this paper I found as a person from a practitioner rather than a research background, not only to be intellectually convincing, it's readable, and I think the takeout message for me is that we're dealing with a very small number of actual children under this in this age bracket of 10 to 13. Predominantly the ones that are more likely to interact with the criminal justice system are in the 13-year age bracket and are most likely to be male. And tragically, as Samuel has just observed by reference to his charts and graphs, over 50% are of First Nations heritage, which again feeds into this whole what I described at the conference last Friday as a national disgrace about the disproportionate number of Aboriginal and Torres Strait Islander people that A, are in our prisons and B, are interacting with our criminal justice system. The paper also discuss in a very helpful way, I think, to policymakers that are looking at this issue, how we can create different models if indeed the minimum age of criminal responsibility is raised to 12 or to 14 as the United Nations proposes. And there are, although this is not mentioned in the paper, there are many examples of programs that are operating internationally and also in Australia that can provide models and assistance to policymakers in developing a response. One that I examined in some detail for the purposes of a seminar conducted by the police union last year to look at the youth justice issue. That's when this issue about very serious offences first kicked off in in the media, and that is the Maranguka Justice Reinvestment Program in Bourke. Interestingly enough, although the New South Wales government does provide some funding, there's also funding from private investment that goes into that. But there are other programs. There's a program in Logan, there's a program in Armidale. There are many. Even the program in Pilbara, which is in a remote Aboriginal community, where the police officers are both fully trained and commissioned police officers. They're not just support officers, Aboriginal support officers. So they're fully commissioned police officers, and one of whom are Aboriginal, one of whom came from the community. And the auditing of that program shows a huge decline in property crime and car stealing because of the understanding and relationship that those police officers have with members of the community. So one of the issues, I think, is engaging community leaders from all sectors, and in particular from the First Nations sector. And there are many people that have a great deal of experience in this area to look at what would happen if we take a number of children out of the criminal justice system by raising the age. The other interesting takeout for me was the reference to research about what is called carve-outs. That is, if we do raise the age, say to 14, what do we do with that small number of 13-year-olds that Samuel mentioned who do commit various serious crimes? We all know from research, and this is not research in recent times, this goes back decades. It goes back to the time when I was president of the Children's Court of Queensland, which is decades, which indicates that any period of imprisonment in custody for a child is likely to damage that child and is likely to criminalise them and is more likely to lead to recidivism and is less likely to enhance community safety. On that very complex issue of carve-out, Samuel and his co-authors in their paper referred to research in Tasmania, which looked at 38 countries where offences like homicide and rape and aggravated sexual assault and armed robbery have been carved out. So there is a lot of information about how that can be done in a way that is appropriate and fair. But as I say, in my humble view as the chair of the council, this paper is an important tool to be considered by policy makers as this issue of raising the age of criminal responsibility is debated on a national level and in the meetings of Attorney Generals. April?
Yeah, no, thank you. Thank you so much for that, John, for those insights. So now we actually move to the discussion where we actually have an opportunity for members of or those attending to be able to raise some of their questions and have you answer those, John, if that's if you're still comfortable to do so. And I'm told by the team that there are a couple of questions that have been raised already. So hopefully we can address as many of those questions as possible. Though again, please, those online, bear with us as we rely on our technology again to work through these questions. So firstly then, John, so some of the community members, they've raised the issue that increasing the age of criminal responsibility will represent a threat to community safety. How would you respond to those concerns?
Well, I mean, I respect that, and there's nothing in our research, nothing in our paper, and nothing in our approach to this subject that undermines the seriousness of what is a very small number of serious crimes committed by this cohort, and mainly the 13-year-old group. I mentioned in my reflection about the way in which we could have a model that would carve out certain crimes from what I could describe as the protection of the minimum age of criminal responsibility. But there are other ways, and I mentioned some of these programs. But look, nothing I say, and nothing the paper says, or the council says undermines or understates that there has to be a sophisticated mechanism in place to deal with this very, very small number of offenders in this cohort who do commit serious offences. But without going into all the detail, a lot of you will know almost inevitably you're dealing with children who are severely damaged. I mean, our analysis indicates that no child in this age group in that 17 years of data that we examined has committed a homicide. But there were certainly rapes and burglaries and serious offences like grievous bodily harm, as Samuel said. So I think we could achieve a balance at the same time as raising the minimum age. And the point I made before in my reflection that detention, imprisoning children, locking children up in watch houses on the basis of the evidence is much more likely to criminalise children and is likely to undermine community safety. So that in itself is something that I'd say to members of the community who are justifiably concerned about this very small number of children in this group that commit serious offences. I'm sorry, that was a very long answer.
No, that's great. No, very detailed. Thank you very much. There were some questions around different measures to deal with young people who commit these offences, and I think you really talked to those before when you sort of talked about some of those alternate programs. So I might move on to then essentially the final question then, which is what do you think the impact will be of the proposed youth justice reforms that for this cohort?
Well, I think inevitably, particularly in the 12 to 13-year-old bracket, inevitably there are going to be more of them placed in custody, either on remand or as sentenced children. And we all know what a vexed problem that is when up to 80% of children in detention or in custody in watch houses and places like that in Queensland on any given day are on remand. That is a problem that just horrifies me. It's always been an issue in this state. At various times we've got it down, but really, I think we've just got to look at this issue of detaining very young children or taking away their liberty in a much more sophisticated way, and simply choosing a model which is essentially punitive will have the opposite effect, in my opinion, based on this research and based on a lot of other information I've looked at over the years, both as a member of the council and as a judge and as a practitioner, because I've always been interested in academic research in this area. So, I think the punitive approach appeals obviously to a sector of the community, but I've found, April, on those occasions when, in the course of undertaking terms of reference at the request of the Attorney General, for example, the child homicide reference. Now, you can't imagine a topic that is more likely to inflame and cause members of the community to be terribly concerned about just punishment and to concentrate on those parts of the sentencing process that emphasise deterrence and community protection. I found, in speaking personally with families of victims of those terrible crimes, then when people are actually given the facts and a bit of information in a non-jargonistic or legalistic way, and not in a patronising way, when they're just simply given some information about the sentencing process, and when they appreciate that courts do feel empathy and do feel great sympathy and empathy for victims, most people, even people that have gone through that horrific sort of loss, respond positively. So that's the key, and that's where I think the council and work like this done by Samuel and the other authors, Laura and Jodie, can contribute so much to balancing the debate. And again, another long answer. It's just the lawyer in me, I think.
It's all good. Actually, John, we've had one further final question that's just come in, and that is just in relation to your thoughts on dollar incapacts in relation to these offenders.
Yeah, this question was raised at the Law Society Symposium discussion about this issue last Friday. And I think Damien Bartholomew from the Youth Advocacy made the very good point, which I sort of backed up, and that is it's really a bit of a fiction. It's there in Section 29 of the Criminal Code, but when you think about it rationally, capacity is not an issue that's considered first up. Sometimes police may consider it when they divert a child, and let's be fair, that's probably what happens. But capacity comes at the end. So that's when the issue of capacity is considered. So, look, I don't think it really offers any protection. I don't think because so many of these children spend time on remand, then they plead guilty, and capacity just doesn't come into it. So it's a part of the Victorian common law, criminal law that we inherited, and there it sits. And as Damien observed on last Friday, if anything, it's been watered down over the last few decades in relation to reform. I sort of did a couple of trials involving capacity, and look, there was no pediatric psychological evidence. It was simply evidence of how the children responded when they were interviewed and that sort of thing. And so I don't have any faith in the capacity issue as providing any form of against children that don't understand what they're doing is wrong, being protected in the present circumstances.
Thank you so much, John, and for those amazing insights. And I think there is definitely so much that can be taken from this paper in so many opportunities to consider things maybe a little differently. So unfortunately, then that actually brings us to the end of our presentation. And I understand that the next meeting of the Council of Attorney Generals is actually due to take place next month. So we may actually know more after that meeting as to the likely direction that will be taken in relation to raising the minimum age of criminal responsibility. So thank you so much, John, and to everyone today, for Samuel as well for the way you presented in providing us being able to present this research to you to you as the audience. So really do want to thank each and every one of you for attending this seminar to hear more about the Council's work in relation to this really important topic. Thank you also to everyone that has made this event possible, and for the technology gods. Hopefully everything has worked so well. So shortly the Secretariat will be sending you through a very short evaluation survey just about this presentation today. So we do ask that you take those 2 minutes. I promise it is very short, just to complete that and provide us with a little bit of feedback. Otherwise, we look forward to welcoming you to any future events that the Council hold. Thank you so much.